the implications of a couple of recent decisions on employment contracts. There was a very significant decision in the High Court recently that found that one of the implied terms into an employment contract that had been assumed for many years by all courts in Australia, the term of implied trust and confidence actually does not exist. The High Court said in that decision, and there's been a number of lower courts as well who recently have said in different contexts, which I'll mention, that an employment contract is like every other contract. It's to be interpreted according to the words of the document. There are a few implied terms that remain which are relevant, but this has been very significant in the sense that for some employees bringing actions, they've sort of against their employer, they'll think, well, we don't really care what's in the terms of the document, we're going to rely on the implied term of trust and confidence or other implied terms. There have been other ways of disadvantage to the employer where this type of reasoning has applied in decisions. For example, two recent cases. One, I think we've all seen, and many of us have probably been party to contracts that have said things like KPIs to be agreed. Now, that tends to be ignored, and then often the KPIs are not agreed. In a recent case, the court said, it says to be agreed, and you're in breach of contract if you don't do it. You can't just, there's a lost opportunity for the employer because this has not been agreed. And the courts are not prepared, certainly at the moment, and I'd say in the next couple of years, to just say, well, it's an employment contract, everything's vague and fuzzy, we'll do what we like. They're not prepared to do that. There's been a couple of decisions on incentive schemes which are similar, because often you'll see a situation where there's these very tightly drawn contracts of employment, but incentive schemes that are drafted and put together by at the workplace, which everyone thinks they know what they mean, but the court's saying, no, this is a contractual document, this means this. This is what it says, so I'm not interested in what people think are the past implications of how it might have been done. It's a contract and it is binding. The other implication was a rather significant case in Western Australia recently where damages were awarded. I mean, we've all seen so many contracts where there's a right to renewal. No one thinks much of it, or we'll have discussions about renewal. The employer didn't, I mean, there are a number of issues in the case, but one of the key issues, I think, from a going forward perspective is the employer didn't have discussions about renewal, and damages for lost opportunity were awarded. So obviously the lessons from this situation is that you've got to get your actual employment contracts right. It's not enough to think, well, it doesn't matter whether we get it right or wrong, there's a statutory regime, so people will bring actions anyway. For executives, not the case. If you can tie it up in the contract, you're in a better position. But by the same token, as an employer or business owner, don't put something in the contract that you can't do. And I'll talk about policies a bit later as well in a different context, but that same applies to policies. I just want to talk briefly about enterprise agreements. Now, enterprise agreements can be absolute nightmare for some employees, but they can also be fantastic because they can offer a lot more flexibility. They can get around some of the issues we were talking about earlier with modern awards. Lucian and I have been involved with quite a number of employers with putting together enterprise agreements directly with the workforce that have provided really significant flexibility benefits, but also cultural benefits to the workforce and bringing people together. But they can be a significant issue, and if they're not done correctly, and there's been a couple of recent decisions and developments in the enterprise agreement area that I think people should be aware of. Every employer wants to retain the right to change your workplace policies if and when you see fit. When we're doing contracts of employment, it's absolutely critical to say that this policy is not part of your contract of employment and can be varied from time to time. There have been a couple of recent decisions just in the last month where employers have attempted to change workplace policies and found themselves thrown into the Fair Work Commission both under dispute resolution proceedings and under no further claims clauses, and been held up from changing their policies. One involved a mobile phone use policy, where the dispute resolution clause in the enterprise agreement gave the Fair Work Commission the right to conciliate and arbitrate on terms and conditions of employment, not just what's covered by the enterprise agreement or what's covered by the award and the national employment standards. A huge mistake, because it means that you're having the Fair Work Commission and the union interfering with operational matters within your workplace. So it's absolutely critical. And there was a decision where shift changes were held up for the same matter. They said this is relevant to the terms and conditions of employment, even though it's not a matter covered by the agreement. And I think one of the most horrific things from an employer perspective was a recent decision where every enterprise agreement will have a no further claims clause, because you don't enter into an enterprise agreement and then expect the union or the employees to want more during the life of the agreement. The no further claims clause in this agreement was held to prevent the employer from changing its motor vehicle policy, because the motor vehicle policy was held to have implications in relation to the remuneration of the employees, which it sort of did in those circumstances. And there was also an arbitration clause in the enterprise agreement. So, I think the lessons, whilst I think enterprise agreements can be fabulous, and I often encourage employers to enter into them if you're dealing with a good workforce, to give yourself some flexibility in relation to penalty rates and so forth. However, it is absolutely essential that your dispute resolution clause, 1, does not allow the Fair Work Commission to arbitrate. Cannot stress that enough. Do not enter into an enterprise agreement that has that. And secondly, that your dispute resolution clause is based on the modern award clauses, which deal only with what's covered in the award or agreement and the national employment standards, and doesn't go more broadly into conditions of employment. Because if you do that, you're going to end up with the union or your employees or the Fair Work Commission telling you how to run the business. So once the agreement is made, and this is not just for people under agreements, this is for people under awards, which almost, every employer will be under a modern award or an agreement for some of its workplace. I cannot emphasise enough the importance of consultation. It was interesting when Lucian was talking earlier about the change to the procedures in relation to the request for an extension for an extra 12 months parental leave, and it having to be a meeting. Now, in my experience with employees and industrial relations, is a lot of employers don't like meeting, quite understandably, meeting with their employees and their staff and their unions and having really awkward conversations like, no, we're not allowing you to extend your parental leave, or we don't like the way your performance is, or we're going to make you redundant. They're horrible discussions to have, but I cannot emphasise enough how important they are if you don't want to end up in the Fair Work Commission and you want to be left alone. The consultation meeting, not only is it legally required, but it helps the situation emotionally. If the employee that's being made redundant, the employee whose shift arrangements changed, the employee who you're not letting extend for 12 months, if you give them the opportunity to vent at you and you sit there calmly and take it, your chances of ending up with an industrial problem are reduced by about 90%. I know that sounds ridiculous, but it is so important to listen to them, to not fight back, to even reflectively listen to them. Sometimes they come up with something that you haven't thought of, I may say as well. But it takes, not only is it legally required, but it takes the heat out of the situation, so that rather than being scared of having the meetings and consulting with the employees when you're making someone redundant, changing their shifts, rejecting their application for flexible work arrangements or extra parental leave, it's actually an opportunity to connect with them. They won't be happy, but to diffuse the situation and to avoid a really nasty employment law situation. So I cannot emphasise that enough. It is required under awards in any event, but it just really, really helps. Just briefly, one of the changes, this is relevant to enterprise agreements, which is why I'm discussing it now, that is proposed to the Fair Work Act involves transfer of business. One of the negatives with having an enterprise agreement is that they transfer if you have a sale of business or changes between associated entities. There's some potential changes to the Fair Work Act, which if they go through, will make it a lot more easy, if done properly, may make it easy to transfer employees amongst associated entities without all the baggage of enterprise agreements or having to deal with 3 or 4 enterprise agreements because you've had a lot of successor provisions coming in. I don't know whether the unions, who would absolutely hate this provision, even understand the significance of it yet, or whether it will go through. But if it does, it certainly opens up some opportunities for businesses to streamline and simplify their arrangements.